Yes, it's on. Hi, if you could please take your seats. We're about to start now. So good evening, good morning, or good afternoon, depending on your time zone. My name is Gabriela Radu, and I'm a junior researcher at the Asser Institute. I would like to warmly welcome you, both those present in the room, as well as our participants online, to our public lecture titled The Right to Health for Women in Armed Conflict, International Law's Role in Addressing the Humanitarian Crisis in Gaza. Firstly, I would like to thank the Royal Netherlands Society of International Law, or KNVIR, for their generous support in organizing this lecture. Without it, we would not be able to gather the experts and gather everyone today in person to discuss this important topic. I would also like to thank Vamika Sajev, our legal trainee that had the initiative to organize a lecture on such an important topic and often overlooked topic. And of course to Baptiste Berrier, who has helped with the organization and development of the program and what we will be discussing today. So thank you so much to both of you. Um, as we all know, the conflict between Hamas and Israel, particularly following the attacks on 7 October by Hamas in southern Israel, and the subsequent military response by Israel has brought or has created immense humanitarian challenges for the population of Gaza. Already a population living under decades-long Israeli occupation and a blockade since 2007. Today, we want to focus on one of the consequences or often overlooked aspects of the conflict, namely the impact on the right to health for Palestinian women there, or for women there. I only have one pair of underwear and I have to wash them with dirty water and then use them again, says Aisha, a fictional name from Gaza, to UNFPA, the United Nations Sexual and Reproductive Health Agency, earlier this year. We think this quote underscores the dire situation of many women facing Gaza and most likely across other conflicts and situations of insecurity, where the basic, the right to health itself has been decimated. In fact, as of January 2024, almost 700,000 menstruating women and adolescent women and girls in Gaza require menstrual hygiene products. They require clean water. They require privacy. The destruction of infrastructure, including hospitals, and the mass population displacement have made water a scarce resource, has led to increased infections and disease and mortality. Our discussion today will try to explore how international human rights law and how international humanitarian law can address these serious violations and how they can protect the right to health for women in the Gaza Strip, the occupied Gaza Strip. Specifically, we will hear today about some of the reporting on the key violations faced by women there as they relate to their menstrual health, their mental health, and their reproductive health. We will then hear about how international human rights law defines this right and how it protects this right, especially as it relates to reproductive violence. And finally, we will look at the international humanitarian law rules relating to the right of health to health in general in armed conflict, as well as it relates to women. And of course, we will look at the challenges to the implementation of these rules, international human rights law, as well as international humanitarian law. We also hope that this lecture might raise an important point, which is that it's essential to incorporate a feminist approach in addressing these needs in armed conflicts, that it's important to recognize the gender-specific impacts of conflict and the unique health needs of women. And we hope that it also challenges the often male-centric perspective of international law. And we hope that you will find this discussion insightful. To make sense of these topics, we are fortunate enough to have with us today, both in person, but also online, three excellent speakers. Our first speaker, Yumna Al-Sayed, who is joining us online, is an Egyptian Palestinian journalist who is based in the Gaza Strip. Yumna is a mother of 4 children. She mentioned that she pursued journalism as a dream and passion rather than as a component of her academic education. Over the past 8 years, she has worked as a journalist for different international news outlets, including CNA, Associated Press, and Al Jazeera English. She says her main motivation has always been to convey the human stories of people and to offer a voice for the voiceless. Our second speaker, Dr. Fleur van Leuven, is an assistant professor in international law at Bogazici University in Istanbul and an affiliated senior researcher with ATRIA, Institute for Gender Equality and Women's History in Amsterdam. She's the national gender equality expert at the Netherlands for the Netherlands of the European Equality Law Network of the European Commission, and was previously editor-in-chief of the peer-reviewed Journal of Gender Studies. Fleur has also published extensively on gender and human rights, in particular on violence against women and girls in pregnancy and childbirth. And for our third speaker here in person, Dr. Vaios Koutoulis. Vaios is a professor of public international law at the Université Libre de Bruxelles, the Faculty of Law and Criminology. Vaios has given numerous lectures on IHL, ICL, including courses for members of the armed forces, humanitarians, and many other professionals. He has also published extensively on IHL and Jus Contra Bellum. Vaios is also a member of the International Humanitarian Fact-Finding Mission, the only treaty-based body that addresses compliance with the Geneva Conventions and their additional protocols. He's also a practitioner. He has been a member of the Belgium in the case concerning questions relating to the obligation to prosecute or extradite, the Belgium v. Senegal case in 2012, and the case concerning, and the Council of Belgium in the recent 2024 advisory proceedings on the occupied Palestinian territory, both before the International Criminal Court of Justice, Vaios has also consulted the Belgian Ministry of Foreign Affairs on ICL questions relating to the Ljubljana Hague Convention on international cooperation in the investigation and prosecution of international crimes. And he has participated in numerous conventions and is chair of one of the 3 main working groups of the diplomatic conference. Yes, we are very fortunate today to have such knowledgeable experts to share their insights on these issues. I thank you all very much for your willingness to contribute to tonight's panel. Following the presentations of our expert speakers, we will all have the chance to ask questions, and the speakers will have the chance to address them. But I ask you to wait until the end for the Q&A session. And without further ado, I would like to give the floor to Yumna. Yumna, you have the floor.
Thank you so much. It's indeed a pleasure to be joining here today at the Astor Institute, and I find it a very important and interesting, honestly, conversation to have today and discussion among different sectors of people, and for it to be discussed, because speaking about women health in areas of conflict is usually neglected at many times. And during the past 8 months, going to 9 months now, the situations that have and conditions that have been facing women in the Gaza Strip have been unprecedented. It has affected their health, not just their physical health, but their physical and their mental health severely. And it's not really a privilege. Well, I have been able to report just a little bit about these challenges and difficulties, but I have felt that these challenges and these sufferings that are being endured by the Palestinian women in or among this conflict or this war that has been taking on for a very long time now has not been highlighted enough, and the necessities that are essential for these women, and some of these necessities are life threatening and life-saving necessities that their entire lives, whether their physical health or their mental health, depends on. So the war on the Gaza Strip began despite the airstrikes, the bombardments, the evacuation from place to another, and the forced displacement for thousands of people from area to another. It was the cutting of the water and energy supply from the Gaza Strip. So the cutting of the water supply that is feeding the Gaza Strip and the energy supply, and Gaza pretty much depends on energy or electricity to generate water from underground so that this water can reach the homes of the civilians. And these two elements of life were cut off the Gaza Strip from the very first beginning, almost the second day of the war. So pretty much on 7th of October, Israeli ministers had already spoken about cutting out the water supply and the electricity supply, and of course, shutting the borders completely and imposing a full and total blockade of the Gaza Strip, which means that no supplies were able to enter for a very long time. The water supply that was cut from the Gaza Strip was the beginning of the best formula for the spreading of diseases among the civilians in Gaza. Diseases that are contagious because of the lack of hygiene, the lack of water in toilets, the overcrowdedness while people were displaced from place to another in very crowded and narrow areas, and without any kind of suitable hygiene, clean water for them to use. There were no proper toilets in these remote areas that people needed to go to. And that was one of the perfect formulas for spreading contagious, infectious diseases among the civilians. And of course, women, girls, children, they're also part of these pretty much affected people. So a lot of times I used to speak to women who were living in these tents, in these remote areas. And it was just one toilet that it was actually made out of a pit in the ground. So it was a made toilet, a man-made toilet, using a pit in the ground where they put a barrel and they tried to make something that looked like a toilet, completely unhygienic, completely unclean, and completely without any kind of privacy or any kind of clean water access to that toilet. So many women used to tell me that they would keep themselves as much as possible away from any kind of food or water so that they do not get to use the toilet more than once a day. And of course, a huge number of people were using the same toilet in different areas because it would be one toilet in every big area with a lot of people, which was also another reason for the dehydration of many women in Gaza, because they kept themselves or prevented themselves from drinking water because they did not want to use the toilet. Going from that, that is just the way how naturally the people would try to cope with their new reality. As the days went by and the month went by, the supplies in the markets were completely finished, and there were no more any sanitary or menstrual cycle hygiene supplies anymore or materials. And almost all the women in Gaza and the girls, and we're talking about girls at a young age up to like 11 years old, who had their periods already coming, they had to resort to other options that were completely unhealthy and unhygienic. They would resort to scraps of material or pieces of cloth. And of course, because of the lack of water, they would stay with these scraps and these clothes, pieces of cloth for a very long time. And very quickly, we started hearing about a lot of infections, among a wide range of women and girls, not just women, but girls, just because of this matter, because of using unhygienic and unsuitable menstrual materials during their menstrual cycles, and they had no other option. Now, all these things that I have mentioned are just the physical pain, the physical tragedies that women were facing. These are just normal women. I haven't even gone to speak about the pregnant women or women giving birth. But these women who were just suffering from the lack of water and the using of overcrowded toilets with so many people, and the lack of hygiene and the lack of menstrual materials, these people had, because of the physical tragedies that they were subjected to, because of the infections and the lack of medication and the lack of space in the hospitals when they went to take any kind of treatment. They were sent back home because there was no enough medication. There were no enough places in the hospitals to take care of them. That put an extra psychological and mental burden and challenge on these women and girls at such a young age. I remember some women were talking to me about their least right of drinking something warm to relieve their pain during their periods. They said we are deprived from that that simple right of being able to drink something warm because we have no cooking gas, and it would take you an hour to light a fire just to boil something warm to drink. And there isn't, for example, there were no lentils, there were no other like other kinds of food, like chicken, lentils, vegetables that they can actually make a soup to make themselves feel better, to relieve their pain, to warm their bodies, their stomachs at this time. So they had to go through all this. So it wasn't just the physical pain and the physical suffering they went through because of because of the exhaustion and because of not being able to rest uh, uh, appropriately at such times because these people were living in tents on the ground, but also the mental conditions of these women and girls. On the other hand, we have more severe situations and conditions that were among women who were pregnant women. Pregnant women in the Gaza Strip during this month of the war, and they were a very large number. I remember speaking to some of the doctors.
Sorry, Yumna, we've lost you. Are you? I think Yumna. Yumna, can you hear us? Are you still there? No. Okay. She lost her connection. Okay. Um, very interesting, very heartbreaking accounts of the situation there. Uh, Perhaps we could have a quick reaction while we wait for Lubna to. Oh, she's already back, so we can continue.
I'm
Sorry.
sorry for that interruption. Sure. So the number of pregnant women in Gaza since October was many doctors have said that they range between 40,000 and 60,000 women that were expected to give birth in this time, or actually have given birth in since October till we're in June now. But I'm saying about, for example, until it was last April, it was from 40,000 to 60,000 women that have given birth in Gaza. Now, since the very beginning, because Gaza Strip is a territory that has always been under an Israeli imposed siege for the past 17 years now. So many of the medical equipments and medications that are required for the health system in Gaza are always denied entering the strip. So already there is an acute shortage of medications, of medical supplies, of medical equipment, x-rays, all these medical machines. The strip has always, or the health system or sector in the strip has always been suffering for years from the shortage or the acute shortage in all these medical supplies and instruments. When you find in the midst of such an aggressive and brutal war that we're talking about 40,000 to 60,000 women are giving birth and nothing is entering the Gaza Strip, no medications entering, enough proper medications that are required to treat all the number of injuries and the women who are expected to give birth, then that was a tragedy. That was a catastrophe in the Gaza Strip. Most women in Gaza during these months had to endure the pain of C-section operations without any anesthesia. And I've seen cases that were stitched. They were literally stitched with very little anesthesia, that they were screaming. And it was like the doctor was telling me in one of the cases at Nasser Medical Complex in Khan Yunis, he told me this is the only anesthesia we can afford to give her. There is nothing left. The amount that is left is going to be distributed on all the women that are going to be giving birth in this time. So that basic, simple right of not feeling that pain, women in Gaza are deprived from. Of course, we've seen numerous amounts and numerous numbers of injuries among children, among women, among elderlies that have been amputed, that have been stitched, that have been left, or their hurts and their burns were changed on without any anesthesia or even painkillers. And yet, we did not, I left Gaza at the end of December, and there were no amounts of anesthesia that were entering as required to the hospitals. In light of all these casualties, we're talking about hundreds of casualties every single day in the Gaza Strip. The other problem with pregnant women, it's not just the enduring of the C-section, the fact that they cannot stay in hospitals after performing the operation or the C-section operation and going through that pain without any anesthesia, without painkillers. They have to leave the hospital to their tents. They have to go to improper and comfortable places where they have to leave that space for other patients or other casualties that would come in no time. So they were sent out, and most of the people were actually staying at the hospitals, at the yards of the hospitals, or in tents in remote areas like Al-Mawasi of Khan Yunis and Al-Mawasi of Rafah. So it's basically all inadequate and comfortable remote areas that are not suitable for a woman who has just been under an operation in such circumstances to live in. That's not the only problem. That's not the only challenge. Then we come to the malnutrition of these mothers. They have no proper or good nutrition available to feed themselves in order to provide breastfeeding milk for their newborns. And this was a major problem because there was no formula. There was no milk for children that were just born. There were no formulas anymore in the markets available, in the pharmacies, in the hospitals at all. So that newborn baby had to depend on his mother to be completely satisfied. And the mother, with the lack of clean water, with the lack of enough amount of water, the mother already being dehydrated without enough nutrition, good enough and proper nutrition to feed her, to make her strong enough, most mothers had their scars after the operation infected because of not being able to um, change on that scar, change the bandages on that scar, or to keep it clean, or to keep it away from being infected. And they were subjected to the lack of nutrition, so they were malnutritioned and they were dehydrated. These are all some of the formulas that were systematically practiced on women in Gaza, a very successful formula to kill that person, not just successfully kill them, but painfully kill them, because you're depriving them of their basic necessities of life. And not just that, they're feeling the pain and enduring that pain every single day. Not to forget the fact that these women are mothers. So they have children. They are the most important element and factor for a family. They need to take care of their children. They need to be there for them and they need to provide for them. And they're not able to do that because of their medical conditions or their health conditions or even their psychological conditions and their mental conditions. So basically, I can I can I have seen a lot that women in Gaza have been through these past months. Um, and it's really not easy because I'm a woman myself. I was not pregnant, I did not give birth, but everything else that I have mentioned, every single woman in Gaza was subjected to, because we all fell under the same umbrella, being deprived of any legitimate necessities of life that we needed. Thank you.
Thank you very much, Yubna, for coming here to speak to us today, and also for the bravery that you've shown by reporting from Gaza following 7 October in a situation of unprecedented violence. And we hope that the following speakers, the following experts, perhaps can offer some relief or some hope that the situation is not as dire as as it could be, and that there is still a role for international law in addressing such crises. So without further ado, I would like to invite Dr. Fleur van Leuven now to take the floor. Fleur will focus on the international human rights law dimension of health. So Fleur, thank you so much.
Yes, thank you. Well, I think the situation is extremely dire. And although there might be a role for international law, I don't think that changes the situation on the ground now, which is, I mean, I'm really hearing your story, and of course I read the reports, but I'm really affected by it. And it's absolutely horrendous. And I think what you're doing, Yumna, is incredibly important because the news needs to be out there. And as you already said, this is a topic that is not discussed generally in international politics, also not in international law, as I will highlight also in my talk. And it needs to be addressed in these arenas. So it's very important that there is widespread media coverage. So thank you very much for that. My talk is going to be a lot more technical than the story we just heard. I'm going to share some slides with you. So I'm going to share my screen now. Yes. All right, so let me just get started. I think it's visible, right? My slides for you as well. I presume that's yes, I cannot see anything. All right, so what I'm going to do is to provide you with a brief overview of how international human rights law addresses issues of menstrual health, of reproductive health, and of maternal health, but I will also focus on reproductive autonomy and on reproductive violence, as you see here as well in the title of my talk. And what I will do is I'll see what obligations we can draw from the international human rights law framework in order to address the lived realities of the pregnant women in Gaza at the moment. And before I start my talk, I have a very brief disclaimer, which is that I'll be talking, of course, about pregnant women, about birthing women, but I do recognize that one does not have to be a woman in order to menstruate or to have reproductive or birthing capacities, just as one may be a woman and not menstruate or have reproductive or birthing capacities. So when I'm referring to women, I'm referring to the rights of everyone that menstruates or that has reproductive or birthing capacities. I want to start with a quote. And this is a quote from a paper of Palestinian scholar Nadera Shalhoub-Kevorkian. The paper is entitled The Politics of Birth and the Intimacies of Violence. It dates back to 2015. And it's based on a study that she did in regards to the experiences of pregnant Palestinian women in occupied Eastern Jerusalem and their experiences in regards to pregnancy and childbirth there. And this is the story of him, who said, "I was walking with my sister-in-law. Both of us were pregnant, barely managing to climb the hill, when the border patrol passed in their jeep. The moment they noticed us, they circled back and threw 3 tear gas bombs on us. When we both started running and screaming, why? Why did you asphyxiate us? Why tear gas? They started laughing and kept on driving." Why I am starting with this quote is because what I want to highlight is what we're discussing today, and already Yumna addressed that as well, is not merely a lack of access to menstrual, reproductive, or maternal healthcare services. We are also not just addressing the unfortunate side effects of armed conflict or the sad consequences of hospitals being bombed, nor are we addressing isolated incidences of individual harm, nor are we addressing violence that only started to occur after October 7th. What we are discussing tonight, I believe, and I'm not the only one to say that, as you can see here on my slide, is structural, institutionalized, systemic violence that devalues, coerces, and harms reproductive bodies. And this form of violence is not only related to armed conflict, it happens in peacetime and wartime. It is systematic, it is widespread, and it's also not unique to Gaza or to Palestine. Reproductive violence has been present throughout history, and there are many examples to be named that people are familiar with, like forced sterilization in Nazi Germany, forced pregnancy in the Yugoslav war in the 1990s, forced contraception and abortion of Yazidi women by the Islamic State. But we also have other examples, for example, the practice of symphysiotomy, which was practiced until well into the 1980s in Ireland, a practice by which the symphysis pubis was artificially separated with a scalpel to enlarge the pelvic diameter, which basically means that the pelvic ligaments were cut, which left women often disabled for the rest of their lives. I'm also talking about enforced medical procedures without the consent during childbirth, without the consent of the woman giving birth. And in her 2019 report, the UN Special Rapporteur on Violence Against Women noticed that mistreatment and violence against women experienced during facility-based childbirth and in other reproductive health services is widespread and systematic in nature. But despite the fact that it is existing since time immemorial, and despite the fact that it is widespread, as was already mentioned also by Yumna, there has not been much attention for reproductive violence, nor has there been much attention in international politics or in international law. And I think that's why it's so important that you are organizing this event tonight as well, so that we can address this question of reproductive violence and see how we can incorporate this into the canon of international law and address it effectively. To get back to the situation in Gaza and in Palestine as well, already in 2005, so this is almost 20 years ago, the UN Special Rapporteur on Violence Against Women, which at the time was Yakın Ertürk, expressed her concern about pregnant women not being able to reach medical services due to military checkpoints and closures. And this led to women giving birth at checkpoints, and this also led to maternal deaths, pregnancy-related deaths, and neonatal deaths. Scholars like Shalhoub Kevorkian, who I already mentioned before, have highlighted how pregnant and birthing Palestinian women face violence not only due to their gender, but also due to race and nationality. ID checks, military checkpoints, fear for imprisonment, partners who are imprisoned, all of these leads to situations where pregnant Palestinian women are unable or unwilling to reach medical facilities required for their pregnancy. Coupled with this is, of course, and this was also addressed by Yumna already, the psychological aspect, which leads to heightened stress, anxiety, and which has been proven to lead to miscarriages as well as to premature births. So what we are witnessing right now in Gaza is an extreme and horrific manifestation and accumulation of reproductive violence against Palestinian women that has already been going on for many decades. So what I would like to do in my talk tonight is to show you or to explain what international human rights law has to say on this matter of reproductive health, but also on reproductive autonomy and reproductive violence, and importantly, what obligations we can draw from the international human rights framework. And as I will show you, the approach of international human rights law at the moment in regards to reproductive violence is too limited. But that doesn't mean that the system doesn't offer handles in which we can use in order to address the lived realities of Palestinian women, and specifically pregnant women in Gaza. So to clarify what I'm talking about when I'm talking about international human rights law, I am focusing in this talk on the on the system for the promotion and protection of human rights as it was established by the United Nations. And in particular, I'm looking at these treaties that you see on the slide, which are considered the core human rights treaties. But of course, there's many other human rights treaties out there. And importantly also, of course, there is the Genocide Convention, which has direct relevance for the topic that we are discussing tonight. And of course, it's the Genocide Convention that forms the basis of the case that South Africa instituted against Israel before the International Court of Justice. And I trust that my colleague who is with you in the room is going to look further at that specific aspect of the lived realities of Palestinian women. So I am going to focus on these human rights treaties, and I'm doing that because these treaties have a global reach, but also because they are applicable to both Israel and Palestine. Both Israel and Palestine are state parties to quite a number of these treaties, which means they have obligations under these treaties that they have to live up to. The treaties that you see here are, as I already mentioned, considered core human rights treaties. They lay down rights for individuals. They also lay down obligations for states that become a party to these treaties. And importantly, also, these treaties that you see here are monitored by bodies of independent experts. That means there is bodies of independent experts that monitor whether states are complying with their obligations under the respective treaties. And we call these bodies human rights treaty monitoring bodies, but I'll refer briefly simply to them as human rights bodies. And it is particularly in the practice of these human rights bodies that we find handles and links in order to address reproductive violence and links to reproductive and maternal health care related issues. So we're going to look at those. But first, let's look at the text of these treaties. So if we look at the text of these 9 treaties that you see here, and this is perhaps unsurprising, but none of these treaties explicitly addresses reproductive violence or manifestations of reproductive violence, such as forced sterilization or forced abortion. The only treaty that comes close to doing that is the International Convention on the Rights of Persons with Disabilities, which is one of the last of these 9 treaties to have been adopted. And this treaty lays down a right for persons with disabilities to decide freely and responsibly on the number and spacing of their children. Besides this provision, we also have the Convention on the Rights of the Child, which lays down an obligation to ensure appropriate prenatal and postnatal health care for mothers. And of course, we have the Convention on the Elimination of Discrimination Against Women, which has an obligation for states to ensure that there is access to reproductive health care as well as to maternal health care, both during childbirth and postnatal. So this is what the treaties mention, which is of course rather restricted, but that doesn't mean that international human rights law does not cover more obligations for states in regards to pregnancy and childbirth, because it does. So although originally these issues of pregnancy and childbirth were not considered to be part of the human rights canon, typically also like issues of violence against women in general were considered to be issues falling within the private sphere, which meant that they were not covered by human rights law. This changed in the 1990s due to several events. And one of the important impetuses for change in this regard were the wars in Yugoslavia and Rwanda, where there was widespread media coverage of sexual violence in those conflicts. And in the subsequent conferences that were convened, world conferences, the World Conference on Human Rights in Vienna in 1993, the World Conference on Population and Development in Cairo in 1994, and the World Conference on Women in Beijing in 1995, what was discussed is the fact that issues of sexual and reproductive health should be part of the human rights canon. And this led to these policies of what is often called gender mainstreaming or integrating a gender perspective into the human rights framework, which meant that from then onwards, these treaty bodies that I just mentioned, starting also addressing these issues of violence against women, different forms of violence against women, as well as issues of sexual and reproductive health, which means that if we look at human rights practice today and we look for obligations of states, it's much more far-reaching than what we find in these actual treaty texts. So if we look at practice today, what we see is, so if we look in the practice of these treaty bodies, these bodies that monitor the implementation of these human rights treaties that I just showed you, we see that the main angle to address issues regarding pregnancy and childbirth is maternal mortality. So that is pregnancy-related deaths. So all treaty bodies agree that maternal mortality is something that needs to be prevented. We don't want any women dying due to pregnancy-related causes. And this is an issue in regards to the right to life, as it is laid down in the International Covenant on Civil and Political Rights. But this is also an issue in regards to the right to health, as it is laid down, for example, in the International Covenant on Economic, Social, and Cultural Rights, or in the Convention on the Elimination of Discrimination Against Women. So what we see is we have this hook or this angle basically of maternal mortality, and what these treaty bodies then say is, okay, states, in order to ensure that women do not die unnecessarily due to pregnancy-related causes, you need to ensure that there is family planning services available and accessible in your jurisdiction, that there is emergency obstetric care, that there are skilled birth attendants, that there is access to contraception and a variety to contraception for that matter, that there is age-appropriate sex education, and that under certain conditions, there is access to abortion. And here you can think of access to abortion when the life of the pregnant woman or the health of the pregnant woman is endangered because of her pregnancy. So this is how these issues are addressed. So what you can see is that if we look at human rights practice in regards to rights in pregnancy and childbirth, there's very much a health-focused approach, which is in a way understandable, because of course it is much more palatable in international politics to talk about preventing women from dying, pregnant women from dying, than talking about reproductive autonomy for women, talking about, for example, because this could also include a right to abortion or a right to decide how and where to give birth, which is more controversial. So quite purposefully, this approach, this health-focused approach, was taken by these bodies, including rights in pregnancy and childbirth in this way into these treaties. So read basically link these issues to provisions in the treaty. So it didn't opt, which it could have done as well, for a reproductive autonomy approach, saying, well, women have these rights because of their physical and mental integrity. It did not do that. That doesn't mean that these treaty bodies do not address any issues of reproductive violence whatsoever. They do, and I'm going to get to that. But before I'm getting to that, I want to focus also on menstrual health very briefly. So what we see that the obligations are for states under international human rights law at the moment, we see that there must be access, I already mentioned this, to skilled birth attendants, to emergency obstetric care. States must prevent unsafe abortions, provide age-appropriate sex education, etc. You see it mentioned here. This does, as you see, not cover the issue of menstrual health. And until a year ago, menstrual health was not discussed in the practice of these treaty bodies. So it is really very recent that this is being addressed. And if we look now in the practice, what we see is that not only is it very recent, but it has only been addressed a few times in the practice of these bodies. And whenever it was addressed by the Committee on the Elimination of Discrimination Against Women. So this is the body, the treaty body that oversees the implementation of the Convention on the Elimination of Discrimination Against Women, which is often referred to as the UN Women's Convention. So CEDAW addresses this a couple of times, this issue of menstrual health, but they do so, interestingly, not in regards to the right to health, but they do it in regards to the right to education. And how they do that is by focusing on teenagers dropping out of school due to lack of access to menstrual hygiene products. So in that regard, CEDAW is arguing that there is an obligation for states to ensure that there is access to menstrual hygiene products and that these are available freely where need be. Moreover, it argues that there should be separate sex-aggregated dimensions sanitary facilities for menstruating teenagers. So it is very limited so far what human rights law is saying about menstrual health, but that doesn't mean that there are no avenues under these treaties to actually further address this topic. And maybe we can discuss this later. First, I want to continue to reproductive violence and manifestations of reproductive violence, because as I already mentioned, although generally there is this health-focused approach to issues of pregnancy and childbirth, we do see that especially when stakeholders, third-party interveners, NGOs bring information to the fore of reproductive violence, that the human rights bodies are willing to take up these issues. So there isn't a reluctance to address them. And we see that in the past, they have addressed forced sterilization, forced pregnancy, and forced abortion in that regard. And these issues are generally brought up together with issues of sexual violence. They're brought up in the context of violence against women or gender-based violence, and they're brought up in the context of conflict-related violence, particularly forced pregnancy. Besides that, there is also incidental attention for symphysiotomy. This is the practice I already mentioned in Ireland, and for shackling pregnant women in prisons during childbirth. And this has been brought up specifically in regards to the United States, but of course we also have reports of the UN Special Rapporteur on Violence Against Women highlighting the concerns in regards to the shackling of pregnant women in Palestine during, in prison in Palestine. Not in Palestine, but in the occupied Palestinian territories during childbirth. Finally, there is the topic of obstetric violence. I will address that as well later and highlight a little bit more what is meant with that. If we then look at the obligations for states in regards to this issue, so we have these treaty bodies that are saying, okay, these are issues of concern to us, this forced sterilization, forced pregnancy, symphysiotomy, etc. If we then look at the obligations for states in that respect, we see that states must investigate allegations of these forms of violence, they must prosecute the perpetrators, and if found guilty, they must be punished, and there needs to be an effective remedy and compensation for the victims. What we already see here is very much a focus by these treaty bodies on after the events have happened, and not so much a focus on preventing these forms of violence from occurring in the first place. And I think this is something where we can really improve upon in international law, and I will address that later. If we then go to obstetric violence, and this is a definition, this is not the definition, I just provided you with this, I'm just providing you with this definition to give you an idea of obstetric violence. But this is also, as Camilla Pickles, who, this is her definition, as she says herself, this is open, this is not exclusive, and many different forms of abuse can actually fall under the number of obstetric violence. So I just put this out here to give you an idea of what I mean with it when I address it. Again, obstetric violence has only been very recently addressed under international human rights law. And it has only been addressed, well, mostly been addressed, there have been some exceptions, by the Committee on the Elimination of Discrimination Against Women, again. So it has only been addressed a few times, and in those cases where it was addressed, the obligations for states in that regard were that there should be legislation in place that criminalizes obstetric violence, there should be accountability in regards to the perpetrators, and there should be remedies for the victims. And in one occasion, CEDAW, the Committee on the Elimination of Discrimination Against Women, also highlighted that there should be adequate and accessible standards of care for medical practitioners. So this is just very quickly taking you through the obligations for states that are currently already mentioned and addressed by these treaty bodies, so that currently exist. So if we look at that, we see that human rights practice does indeed address issues in regards to pregnancy and childbirth. There is attention for access to reproductive health, there is attention for access to maternal health, there is attention to preventing maternal mortality, and also there is attention for protecting women from certain forms of reproductive violence. I would, however, argue that due to this health-related or health-focused approach in international human rights law regarding issues of pregnancy and childbirth, there is insufficient recognition for agency or autonomy, if you like, in pregnancy and childbirth. And there is also not enough attention for the multifaceted nature of this type of violence, as well as the way in which intersecting inequalities that Palestinian scholar Shaloub Kevorkian also referred to, these intersecting inequalities are underlying these practices and these manifestations of violence. So recognizing that pregnant and birthing Palestinian women face violations, not only due to gender and related harmful gender stereotypes, but also due to their race and their nationality is, I believe, pivotal in effectively addressing these violations in law. Similarly, attention must be paid to the multifaceted nature, I already mentioned this, of reproductive violence. These are not isolated incidences of abuse. They are not set side products of an armed conflict. These are structural, systemic forms of violence, and they operate on many different levels in society, and they may relate and be reinforced by biopolitics, they may reinforce power hierarchies, and they may be related to gender stereotypes. Despite the shortcomings of international human rights law, I do believe international human rights law offers a framework in which we can address reproductive violence and also can address the lived realities of the women in Gaza, at least from a legal perspective, which of course does not take away from the extremely horrible situation in which these pregnant women find themselves in. And the rights I want to highlight in this respect are in particular, well, first of all, the right to be free from torture, inhuman and degrading treatment. I would argue that if we look at what has just been outlined by Yumna, the experiences of women in Gaza today, that many of these experiences actually meet the threshold of torture or inhuman and degrading treatment. And then I'm not only looking at the physical aspects of these experiences, but also at the psychological aspects of these experiences. The Committee Against Torture actually already has previously found that denial of access to emergency contraception, abuses against women in reproductive health care facilities, denial of post-abortion care, all these amounted to violations of the prohibition of torture and ill treatment. So there is precedent there to address that. I think what is important under international human rights law, of course, and we saw this when we looked at the obligations, states have, of course, an obligation to protect individuals and to that end to prosecute perpetrators and to ensure that they are punished in accordance with their crime. But what I think is also important is to focus on the obligation of states to prevent torture and ill treatment. And I think in this regard, a lot of ground can still be gained in international law. This obligation to prevent torture can be understood, I believe, also as an obligation to address this multifaceted nature of reproductive violence, and also include obligations to, for example, raise awareness of these intersecting inequalities and ensure that they are not embedded and reinforced in policies, in regulations, and in practices. And also ensure that practitioners, be it judges, be it police officers, be it healthcare practitioners, receive adequate gender-sensitive training. And these are just some of the aspects in that regard of this obligation to prevent. Besides that, of course, very obviously, I would say, there is the right to life that plays an important role. And as Yumna already said in her talk, she spoke of the successful killing of these women and the purposeful and painful killing of these women. And I think the denial, the intentional denial and obstruction of reproductive and maternal health services to pregnant women certainly leads to violations of the obligation to respect the right to life, as well as the obligation to fulfill the right to life. Finally, and then I'm going to close this part of the International Human Rights Framework, we should also address the full potential, I believe, of the right to non-discrimination. What we see right now in human rights practice, not so much only in regards to reproductive violence, but in general, is a very reductive interpretation of this right to non-discrimination. So generally, discrimination is seen as direct or indirect discrimination in one-on-one encounters, rather than looking at it as expressions or manifestations of systemic discrimination, often on intersecting grounds. But I think there is scope there to improve that, if there is a willingness, of course, of international human rights practice to take that up. So I do think the International Human Rights Framework offers us some handles to address reproductive violence also within the context of Gaza, but at the moment, the system is not sufficient in addressing these situations. Briefly then, we're talking about human rights. Of course, international human rights law also applies in situations of armed conflict. It doesn't just stop when a conflict emerges. State parties are also responsible during armed conflict for all their actions affecting human rights, regardless of whether the affected persons are in their territory. And international human rights law also requires state parties to regulate the activities of domestic non-state actors within their effective control, who operate extraterritorially. Finally, and then I'm almost there, in regards to enforcement, yes, these are international human rights law typically sees on the relation between the state and individuals within its jurisdiction. And in this case, the obligations I just mentioned typically rest upon Palestine and Israel, who are parties to these treaties. But I would really like to highlight the role of third states in enforcing international law. Of course, if international law is not enforced, it loses its value and its authority. So I think, and this is a quote from the UN Special Rapporteur on Violence Against Women already from November, I think what is needed here is that this issue is taken up. And of course, we see states, some states doing that already, is taken up by states, by other states as well. So to conclude, and then I'll be done. In the 1990s, we saw this shift of recognition of sexual violence as being an issue under international criminal law, international humanitarian law, international human rights law. And what really gave an impetus to recognizing that sexual violence, and actually violence against women at large, was an issue of international human rights law was the fact that there was widespread media coverage of the sexual violence that was occurring in Rwanda and Yugoslavia. And this created an outcry also in the international fora, so the world conferences I already mentioned, because it highlighted how ridiculous it was that these issues were not addressed by international law. So this created a change. So what we see since then is that many issues of many forms of violence against women are now following this practice of gender mainstreaming or integrating a gender perspective, however you want to call it, are considered part of the human rights canon. I think it's high time now we also address the fact that reproductive violence as a separate form of violence should be properly addressed by international law. So we must make sure that we do better from now on. That is my talk.
Thank you so much, Flor, for taking us through this very complicated legal system and regime, but also the potential to use this regime to highlight or to address gender-specific needs. I will have to directly move on to our third, but not last speaker. Bios, you have the floor. Thank you so much.
Thank you very much. Good evening, everyone. Thank you for inviting me. It is a privilege to share the panel with the previous two speakers. And it was a harrowing tale, the one that we had from Yumna. And I have to say, I am humbled by the experiences and the difficulty that she must have faced in order to report these events. I was asked to speak about how international humanitarian law addresses the right to health in armed conflict in relation to women and the challenges posed to its implementation. And not to speak only about the provisions relating to women and the right to health, but also give a more general contextual presentation of the right to health in general in armed conflicts. So I will have three main parts in my presentation. I will start from the general rules relating to right to health during armed conflict. So have a quick overview of how IHL deals with health and healthcare in armed conflict. I will then move on to the more specific rules relating to health and women in armed conflict, because IHL does have such rules. And then I will deal with how can we see these rules applied or not applied in the situations in Gaza. So the third part will be more about the challenges. So starting from right to health in general during armed conflicts, I would say that, let's say, if we have a more broad perspective of IHL rules, very many IHL rules are about health, if you think about it. You have the first and the second Geneva Conventions, who are all about wounded and sick people, the first on land, the second on sea. So basically, and then you have the third Geneva Convention focusing on prisoners of war, where you have a number of provisions on detainees, and then the fourth focusing on civilians, where also you have a number of provisions dealing with healthcare and humanitarian assistance and the obligations of the occupying power and all that. So if we adopt a broad view, there is a big number of IHL rules relating to health and therefore to the right to health. So first of all, if we think about the wounded and sick in armed conflict, there is of course the main fundamental rule to respect and protect wounded and sick. That's the rule articulated, for example, in Article 12 of the first Geneva Convention. And then linked to that, there are a number of, let's say, rules that basically give some meat to that general obligation to respect and protect. I will not cite each and every one of these rules. Otherwise, I would just be citing each and every article of the Geneva Convention. But this includes, for example, the duty to search for the wounded and sick, the duty to collect them, the duty to evacuate them if circumstances permit, the duty to provide them with medical care, the fact that parties must ensure that adequate medical care is provided as far as practicable, etc. And of course, linked to that, all the rules relating to the specific protection applicable to medical personnel and medical units. So all the protection accorded by IHL to ambulances, hospitals, etc., are in a very big way linked to ensuring the right to health of the wounded and sick. And they are meant to protect, to allow rather, to protect this personnel and therefore to allow it to effectively give the population needed, the combatants in this case, the health care that they need. So everything that has to do with the special protections afforded to medical personnel can also be considered as part of the rules of IHL relating to health and to the right to health. If we go to, secondly, the rules relating to prisoners of war or detained civilians, in other words, persons that are detained in armed conflicts, there as well you have a number of rules dealing with health, both in the third and the fourth Geneva Convention. You have a whole chapter in the third Geneva Convention dealing with hygiene and medical attention of prisoners of war. So the obligation for the detaining power to take all sanitary measures necessary for detention camps, to provide sufficient food, to have an infirmary, to prevent diseases, etc., etc. Again, I will not, cannot cite each and every rule, but just to give the general idea that there are really a number of very, very detailed rules as to how detainees, both if they're prisoners of war or if they are civilian internees, how their health care must be taken into account by the detaining power. Again, there is here a special status afforded to medical personnel, since if you look at the third Geneva Convention, when you have medical personnel belonging to armed forces that you detain, they get the treatment of prisoner of war, but they don't have the status of prisoner of war. So they are also elevated to a different status, let's say, than the common combatant who can be detained because he's a prisoner of war. They shall receive, says Article 33, as a minimum, the benefits and protection of the Third Geneva Convention, of course, and shall be granted all facilities that are necessary for the medical care of the prisoners of war in the detention camp. If we move on to the civilian population, then in general, the Fourth Geneva Convention also has provisions for civilians that are wounded and sick. And then again, protecting hospitals and medical units. These provisions are similar to what we find in the First Geneva Convention. And you have the not many, but very, very important provisions relating to occupied territories. Because there you have, for example, Article 55 of the Fourth Geneva Convention, which says that the occupying power has the duty to ensure food and medical supplies of the occupied population to the fullest extent of the means available to it. It's not an absolute duty, but it is a very, very explicit duty nevertheless. And then when we move to Article 56, it gets even stronger, again to the fullest extent of the means available to the occupying power. This power has the duty to ensure and to maintain, among others, public health and hygiene in the occupied territory. So this is a very broad duty. When you're talking about ensuring and maintaining public health and hygiene, you're actually supposed to, well, do everything that you can in order for everything that can be encompassed under the terms public health and hygiene, in order for them to be, well, correctly maintained in an occupied territory. So here we see how similar the position of an occupying power is to the one of the government. They're both administering the territory. One is sovereign and one is not, of course, but nevertheless, the occupying power is also administering the territory. As the administration of the territory, it has a duty to maintain and ensure public health and hygiene. And it is also that article that goes into so much detail as to discuss situations of contagious diseases and epidemics, since the occupying power is also supposed to adopt and apply prophylactic and preventive measures in order to prevent epidemics and diseases and contagious diseases. This is the article that, for example, was relevant when we were in the COVID-19 health situation and we were discussing obligations of the occupying power in relation to providing vaccines, for example, to an occupied population. And then Article 59 provides the obligation of the occupying power to accept humanitarian assistance. So the idea is that if the occupying power does not have the means available to do everything that Articles 55 and 56 oblige it to do, then it has to accept the humanitarian assistance that is sent into the occupied territory. So the idea is that if you combine all these three articles in an occupied territory, normally you should not fall below an acceptable level, an acceptable threshold in terms of public health and hygiene. And then you have, again, a number of more specific rules. I will not get into too much detail. I do wish, however, to highlight Article 49, paragraph 3 of the Fourth Geneva Convention, which discusses the temporary evacuation of civilian population. Normally, you're not supposed to deport civilian population. That's what paragraph 1 says of Article 49. Paragraph 2 says, well, in some situations, if it is for the protection of the population, you can temporarily evacuate the civilian population. And then paragraph 3 comes in and says, well, if you do so, when you temporarily evacuate the civilian population, then this evacuation must be made in satisfactory conditions of hygiene, of health, of safety, and of nutrition. So in the context of evacuations in occupied territory, that is a very, very important, it seems to me, provision to be taken into account. And then the last point I wanted to make in this first general part relates to people with disabilities, because this is another aspect or another group of protected persons who are designated as such in the sense that IHL rules already provide for special protection for people with disabilities. The language of the Geneva Conventions is, of course, the language of the 1940s. So people with disabilities are designated as infirm in the Geneva Conventions. But nevertheless, you do also have a number of rules according special protection to people with disabilities. Rules which, of course, as Fleur has said, must be read also in light of human rights law, which continues to apply during armed conflicts. And it is there that the 2006 Convention on the Rights of Persons with Disabilities comes in. I will now move on to the second part of my presentation and zoom in on the right to health for women in particular. I will not discuss the place of women in IHL in general. I will not discuss the correct criticism that has been leveled against the IHL rules and the passive view that the formulation of IHL rules has and circulates with respect to women. So all the gender-related criticism of the correct gender-related criticism of IHL rules. I will not discuss that. I will not discuss also women as victims of sexual violence or rape in particular. I will just present the general outline. So you do have here again some important general rules relating to the protection of women. For example, Article 12, paragraph 4 of the First Geneva Convention. so that's the one relating to protection of wounded and sick members of the armed forces on land, says that women shall be treated with all consideration due to their sex. And you should note that the first additional protocol in its Article 8, alinea A, includes in the definition of wounded and sick maternity cases and expectant mothers. So they are defined as wounded and sick under the first additional protocol. This is because they are persons in need of immediate medical assistance. Along exactly the same lines, when you go to the civilian population, when you go to prisoners of war, so the third Geneva Convention, you have a similar article, Article 14, paragraph 1, which says that women prisoners of war shall be treated with all regard due to their sex. So there is this general invitation to take into account the specificities and the special protection that women may have when they are wounded or sick, or when they are detained as prisoners of war. And then you have the first additional protocol, who in its Article 76 has the general obligation according to which women shall be the object of special respect. And then there is the article continues saying that they shall be protected in particular against rape, forced prostitution, and other form of indecent assault. But there is still that general obligation relating to the fact that women shall be the object of special respect. And you find this also in the ICRC customary law study, whose Rule 134 also discusses the specific protection, health, and assistance needs of women who must be respected during armed conflict. So these are the general rules, which again, at the time when the Geneva Conventions were adopted, were already probably one step ahead of what existed in international law. Nowadays, as Fleur reminded us, because human rights law continues to apply during armed conflict, these general obligations to treat women with all consideration due to their sex, or to the fact that women are the object of special respect, must be interpreted according to everything that has been said by Fleur before relating to the evolution of human rights law and women's right to health. Nevertheless, there are, again, a few more specific rules dealing with the protection of women's health in armed conflict that can be grouped around two situations. Women are granted special protection in IHRL when they are detainees. So there are a number of provisions in detention situations. So the Third Geneva Convention, prisoners of war, or the Fourth Geneva Convention, civilian internees, explaining what does treating women with all regard to their sex means. And here, the idea is, for example, that when they are detained in camps, normally women prisoners of war are accommodated in separate, either separate buildings or separate sections. So separate conveniences shall be provided for them. They must be under the supervision of female personnel, not of male personnel. When we're discussing about repatriation, for example, or sending prisoners of war to a neutral state, the fact that you are an expectant mother, for example, is to be taken into account in order to have priority in repatriation or in being transferred to a neutral state. Or if you sentence a prisoner of war, if you convict a prisoner of war, either in disciplinary manners or in penal matters, again, a woman prisoner of war against which a sentence is pronounced shall be confined in separate quarters and shall be under the supervision of women, says Article 108. So you do have specific rules for women as detainees. And the updated protocol, the updated commentary to the Third Geneva Convention confirms this idea that I was explaining before, that when you're discussing women as detainees and you're analyzing or you're interpreting what treating them with all regard due to their sex means, you must take into account the fact that they must have access to sanitary products, medical services adapted to address women's gynecological and reproductive health issues and the like. The second situation or specific protection relating to women in armed conflicts has to do with women as mothers. And there again, you have special references to pregnant women or mothers of infants or mothers of young children, establishing further protection to women when they are in these situations. There is a slight difficulty with terminology in the Geneva Conventions in this respect, because the terminology used throughout the relevant articles is not exactly uniform. So sometimes we talk about expectant mothers and mothers of children under 7 years old. Sometimes we talk about expectant mothers and maternity cases, and we don't know exactly what is a maternity case. But the rationale behind all these different provisions is basically the same. So the idea is that you are in a situation or you're faced with persons that need special protection, and therefore the rules are animated by this main idea. So I would suggest that the range covered would be from expectant mothers to mothers of children at least under 7 years old. And therefore, here again, you have a number of specific rules. For example, in the Fourth Geneva Convention, Article 16, which says that the wounded and sick and expectant mothers shall be the object of particular protection and respect. Article 17 says that if you are in a besieged area or in an encircled area, the parties, that's not a very strong obligation, of course, shall endeavor to conclude agreements in order to remove as a priority wounded, sick, infirm, and children and maternity cases from besieged areas. So you do have a certain number of rules taking into account the specific protection needed relating to mothers. Now I'm moving on to the third and final part of my presentation, since I see that my time is slowly coming to its end. The lack of respect for these rules, because we have the rules, and if we interpret them properly, especially if we insert all the evolution that we have from human rights law, I don't think that there is a problem with the rules as such, at least in IHL. The problem is rather with their implementation. And again, everything that Yumna has discussed proves how big the gap is between the law as we see it on paper and the Geneva Conventions and the additional protocol and the ICRC customary law study and all that from the reality on the ground. So yes, what happens in Gaza or in other situations in all probability constitutes a violation of a big number of the rules of international humanitarian law. If you look at the request for arrest warrants, the statement made by the ICC prosecutor on the 20th of May 2024, among the war crimes listed for at least the Israeli suspects, you find starvation as a war crime, you find the willful causing of great suffering or serious injury to body or health, or the cruel treatment, again as a war crime. You find persecution as a crime against humanity, and you find other inhumane acts as a crime against humanity. So we don't have the exact explanation of specifically what kind of acts fall under these incriminations, but I think it's not implausible to suggest that at least a very big number of what was described earlier by Yumna is taken into account for a number of these crimes to, well, at least be considered as being plausibly committed in Gaza. And one should not forget that it's not only about war crimes or about crimes against humanity. These acts may also constitute genocide, as at least the application of South Africa, in the case of South Africa against Israel, suggests. So if you read the application instituting proceedings by South Africa, the one in submitted in December 2023, you see that there is a number of incidents relating to the effect of hostilities on women that are taken into account in order to prove the existence of acts of genocide and the intent to commit genocide. And I wanted also to focus in particular to one of the 5 acts of the crime of genocide, the one that is described in alinea D of the definition, the act of imposing measures intended to prevent births within a group. What South Africa suggests in its application instituting proceedings is that the reproductive violence inflicted on Palestinian women, on newborn babies, infants, and children constitutes the imposition of measures intended to prevent Palestinian births in Gaza. And indeed, if you look at the facts that are being brought by South Africa, again, the application dates from December, so the facts are relate to what had happened in 2023. They're not informed by whatever has happened since. But even then, you have 70% of those killed estimated to be women and children. 2 mothers are killed every hour in Gaza. At least 4,700 women and children are reported missing. Multiple eyewitnesses accounts of pregnant women being killed by Israeli soldiers, including while trying to access healthcare. Pregnant women and children are particularly impacted, of course, by displacement, lack of access to food, water, what we have heard. An estimated 5,500 of approximately 52,000 pregnant women in Gaza give birth each month in unsafe conditions. When they get to hospital, they have to undergo cesarean sections without anesthetic. Again, we heard about this. Lack of access to medical supplies, including blood, means that doctors are compelled to perform hysterectomies, which would normally be unnecessary. And these hysterectomies, mean that the Palestinian women will be unable to have more children afterwards. So these are the facts that South Africa puts forward, substantiating the fact that, well, if you combine all of these, then you have the imposition of measures intended to prevent births within a group. So we have to see, of course, how the ICJ will tackle this. There is an added difficulty with this alinea note, is that there is a second intention imposed by this alinea. So there is already the difficulty with the crime of genocide, because you need to prove the dolus specialis of intending to destroy a group such. But this alinea requires that the measures are intended to prevent births as well. So you have a second intention that you need to prove. So this is, you have an additional difficulty that must be highlighted in this respect. So what is also another point I wanted to make, my last point before I conclude, is that all these rules and the special protection afforded to women, despite of being obligations as such, they must also translate into the interpretation of other IHL obligations, namely the obligations, the basic fundamental obligations relating to the conduct of hostilities. Which means, for example, that when you're thinking about obligations relating to precautions in attack, and you're planning your attack, you must take into account the fact that there are groups such as women that are specifically protected under IHL. When you're analyzing the application of the principle of proportionality and what we call the collateral damage side of the principle of proportionality, you must take into account the reverberating effects of your attack and the consequences that your attack may have on specially protected groups such as women. So it's not about the rules themselves, it's also about the effect that these rules can have on other rules of international humanitarian law. So the rules are there. And the challenges to their respect are similar actually to the challenges that respect for other general rules of IHL have. I would underline the danger that we see in at least modern warfare, although the danger to my mind is not that new, of parties to the conflict exploiting the exceptions, interpreting the exceptions very broadly, and in the end, flipping the rule on its head or turning the rule on its head. Civilian casualties are supposed to be the exception in an armed conflict, not the rule. The rule is that civilians must not be attacked and that they may be protected. And then there are, yes, certain exceptions, but they're supposed to remain the exceptions. So when you overinterpret the exception, then the danger is that the exception will become the rule at the end of the day. And the second danger is the exceptionalism that we see in the arguments of states justifying violations of IHL. The distinction between jus ad bellum and jus in bello, the equal application of IHL to all parties to the conflict, is a rule that almost everyone knows and we usually recite. And at the beginning of every IHL course, we say, well, IHL applies equally to all parties to the conflict, and that's accepted by everyone. In reality, it is not as easy to be continuously aware of that fact, because what you see is that in the justification of the violations, you see jus ad bellum considerations creeping in. And you see the tendency to say, well, our conflict is different, our reaction is legitimate, so this somehow allows us to be a bit more relaxed in the way we approach the application of the obligations that we have under IHL, of distinction, of proportionality, of whatever. So it is very important to keep in mind the equal application of IHL and to keep IHL, let's say, pure from being infected by jus ad bellum or legitimacy considerations. And I will leave it at that. Thank you very much.
Thank you very much, Vios. And I think we could all agree here that indeed the time of just war explanations and theories and justifications by states are long gone and should be left in the past. I think as we don't have so much time left, we can jump in with questions directly. First, I would like to give the floor to members from the in-person audience. So please raise your hand and my colleague will come to you to take your question. I would also ask you to please introduce yourself before posing your comment or your question. Thanks, guys.
Hi. First of all, thank you all for the information. Um, my name is Shaki. I'm a recent graduate of Leiden University. My question is kind of what does international law and IHL have to say about states not directly parties to the conflict but are providing arms or withholding aid, and what frameworks of accountability can they have as related to what is happening in Gaza, as well as what is happening in the West Bank and broader?
Thank you. Are there other questions? Perhaps if these experts agree, we can take a few questions and then answer. Yes? Okay.
Hi, I'm Caleb Wheeler from Cardiff University. It seems to me in listening to these talks that there's a disconnect between the first talk and the second two talks, in that the first talk is dealing with the lived experience of women in Gaza right now, while the second two are dealing with the fact that really we can only address the effects of this after the fact, you know, and sort of looking at the subtitle of the talk, addressing the role, international law's role in the crisis, it seems to me the answer almost is we don't have a role in the crisis as international lawyers right now. Our role comes later. And I'd be interested in the panelists' thoughts about that. Is this an inherent problem with international law? Is it a solvable problem of international law that it's a responsive field, that we can't address what's happening in Gaza right now as international lawyers? What we can do is down the road, hopefully, find accountability for the things that have happened. Thank you.
Hi, my name's Alex. I'm a PhD student at Brunel University London in international terrorism law. And I have a question regarding statelessness. We see a lot of stateless persons in camps in Syria, and the humanitarian crisis there is quite large. So I was just wondering, where does IHL fit into women in these camps that have come out of terrorism, and what is there to do about someone who's been stateless, and what does IHL say about being stateless in camps? Thanks.
Final question here, Vamika. At the front.
Hi, Janet Anderson, a journalist. I was wondering, I mean, I know that the subject is Gaza, but I was wondering about other humanitarian crises around the world and whether they might also teach us something to be able to say also on Gaza. I was thinking about what's happening with women in Sudan, and I was thinking about maybe some of the issues of women in Ukraine and some of the occupied areas there, whether there are some cross parallels to be made.
Thank you for your questions. I believe the first question was related to secondary liability, right? So states that are not parties to the conflict. Ayos, would you like to take this question?
Yes, I can address the questions that I can if my co-panelists agree, and then maybe we can move on the floor to them. Okay, thank you. Right, so the first question, states not parties to the conflict, what can they do? Thank you for the question, because it allows me to discuss the obligation to ensure respect of international humanitarian law, set down in Common Article 1 of the Geneva Conventions, a fundamental obligation. And of course, they have third states, I mean, as well as international organizations. Don't forget international organizations. They also have the obligation to ensure respect, as confirmed by the ICJ in its Wall Advisory Opinion of 2004. And it is in the context of this obligation that providing weapons, to belligerents or withholding humanitarian assistance to belligerents and the like will be addressed. As I would say, the proceedings brought by Nicaragua against Germany confirm there is, again, if you look at the application instituting proceedings in that case, there is a specific reference to the obligation to ensure respect, and there is also reference to similar obligation coming from well, the Convention Against Genocide. So there is also, and I think what Fleur mentioned about the obligation to prevent torture also comes under a similar idea. So this obligation to ensure respect, in my mind, can be found certainly in IHL and then can prohibit a number of these actions, but is also to be found in international human rights law. And I'm sure Fleur will complement me on that. The second question, is IHL responsive by definition? No, it is not. The thing is that IHL usually becomes visible afterwards. The first actors that apply IHL on the ground are the belligerent parties themselves. And they're supposed to apply it, and they do apply it already before the very first attack starts. IHL is there and is applied from the preparation of the attack. So through even before the beginning of the conflict and throughout the conflict, IHL is applied. The thing is that IHL, it's like criminal law. You only see its violations. When IHL is respected, you don't hear about it because there's nothing in the news. And there are several incidents of armed conflicts where IHL is respected. And I have talked quite a lot with members of the armed forces, and I've heard accounts of attacks not being conducted in the end because the pilot, for example, realized that what was supposed to be a military objective was not. So the attack was cancelled, according to the obligation of Article 57 of the First Additional Protocol. So there, you don't hear IHL was there, it was applied, and no one ever hears about that. So we only hear about IHL's violations, which then, of course, naturally brings up the question of what are we going to do about the violation? Hence, the reactive approach. But it's not because that's the visible aspect that everything that happens before does not exist. Statelessness and IHL. Well, there are provisions in IHL that discuss nationality, and there are provisions in IHL that are supposed to be applicable to everyone. So, for example, the Third Geneva Convention dealing with prisoners of war, and the first and the second for that matter, do not have any limit as to their personal scope of application depending on nationality. And there is also a non-discrimination clause relating to the fact that the convention is to be applied to every detainee, irrespective of their nationality. So, and this, I would suggest, is also valid for non-international conflicts. So in detention situations, let's say, nationality will not necessarily come into play, or the absence of it will not necessarily come into play for the protection of the persons under IHL, right? The Fourth Geneva Convention has a provision on nationality. Article 4, paragraph 1 of the Fourth Geneva Convention specifically states that the persons protected by the convention are the nationals of your enemy, which has brought up the difficult question of what do you do with your own nationals who side with the enemy? For example, what do you do with a pro-Russian Ukrainian national who is fighting with Russia against Ukraine? A civilian, or a pro-Russian civilian who participates directly in hostility from time to time. He is pro-Russian, but he stays a civilian nevertheless, right? And then he's captured by Ukraine. If you follow the letter of the Fourth Geneva Convention, that person is not entitled to the protection. However, the enemy of that person is Ukraine. It's not Russia. Let's put it differently. The state from which that person needs protecting, it's Ukraine, since the person is pro-Russian. It's not Russia. So this is what prompted the ICTY when confronted with this problem to say that we should apply the Fourth Geneva Convention depending on the allegiance of the person and not of nationality. So again, if you follow that approach, which is a contra legem interpretation, it goes against the letter of Article 4, but it fulfills the object and purpose of the convention. If you go with this interpretation, then nationality becomes irrelevant also for the Fourth Geneva Convention, and therefore, again, the absence of nationality and statelessness also becomes irrelevant. I've discussed a lot, I think. I've talked a lot. So maybe I should let my co-panelists do the rest.
Yes, I think perhaps we can also move to the online speakers, but also the online participants. I believe we already have a few questions for both Fleur and Yuvna, but I will let my colleague Baptiste read out the questions. Thanks, Baptiste.
Sure. I have a question for Dr. Piali Chatterjee. She's assistant professor at the ICFAI University, Raipur, India, and her research focuses on health law, particularly the reproductive rights issue of women, criminal law, human rights, women and law. And she's asking two questions that I think are directed at Dr. Fleur van Leeuwen. The first is, why can't we frame laws particularly related to protection of reproductive health during armed conflict? And the second one is, why the International Red Cross is silent or failed to provide relief in Palestine? And I have a third question from Natalie Schellin. She's studying communication and information communication information studies at VU Amsterdam, and she is asking, what is the use of reciting these rules and convention if they are currently not being followed? What does this do? Thank you.
Yes, I'm thinking maybe it's best if I answer the last question first, and also there was a question left from the audience which concerned the cross parallels between the different conflicts. So maybe I can address those two, and Vios, if you can take the one, because I actually think the other one relates to international humanitarian law, because it sees specifically to the laws during times of armed conflict, which I think actually you addressed. This question already was there when I gave my talk, but I think, but please correct me if I'm wrong, Dr. Piali, this question has been answered already by Vios in his talk, I think. So I'll go to the last question first that was asked in the chat, and then I'll go to the cross parallel question that came from the journalist in the audience. Yeah, the last question, it's a question I get a lot actually from my students, my political science and international relations students, wondering why we're actually having a course on international law in the first place if international law is violated. And I think this also actually relates to what Caleb just asked, the question that Caleb asked in the audience, and which Vios already answered, the question Vios already answered. Because I think we have to wonder, yes, I mean, of course, there is laws in place and laws get violated. That's of course the same for domestic laws, by the way. There's domestic laws in place and still people get murdered and still there is robberies, etc. I think what we need to wonder is, would we be better off if we didn't have these laws in place that regulate interstate behavior and that regulate also in regards to international humanitarian law, the behavior of individuals in armed conflict. So I think that's something we have to wonder. So just the fact that there are violations occurring and they are atrocious. I mean, what we have been discussing tonight is really horrendous. And specifically also, if we see the responses or the lack of responses of quite a number of states, then that is really worrying also for the field of international law. I don't think that means that international law is useless or doesn't have a role to play. I also don't think it means international law is only responsive, because I do think it does shape our understanding of how to act during wartime and what to expect from states, but also in peacetime, specifically also in regards to international human rights law. So yes, I do think that there is a role to play for international law in that regard. In regards to the cross parallels, because I think we're running out of time, so I'll be quick. Yes, this was actually, and I think I'm very happy that you brought this up, because this is a very important issue. Reproductive violence in many different forms and shapes takes place in armed conflicts throughout the world, but also takes place in peacetime throughout the world. So it's something that is ingrained and embedded in societies. And it's something that is just generally not garnering much attention. It's something that just is a side product of the fact that women give birth, and that these are the consequences. So we don't pay enough attention to it. So I think, yes, we see this, there is these parallels amongst all these different situations. And it's important that international law, international humanitarian law, and international human rights law specifically also addresses these forms of violence. So what we saw in the 1990s, and what I was trying to refer to, is this recognition that sexual violence is actually occurring widespread. And until that time, sexual violence was just considered to be something that just happened to happen during war. Yes, soldiers rape women, but it wasn't specifically addressed as a violation under international humanitarian law or under international human rights law. And this changed. So what we need is also this recognition of reproductive violence as a specific form of violence that is present, not only, as I said, during armed conflict, but also during peacetime. So yes, there is definitely cross parallels. And we really need to address this issue in a careful way within international law. So this was very quickly addressing those two questions. I think the other question, maybe it is already answered. Maybe we can ask Dr. Piala whether that question has been answered sufficiently by Fayos in his talk.
I believe this question we could discuss forever. Therefore, I suggest perhaps giving the floor for one last question if there are quite a few. Yes, one last question.
Yes, okay. I'm Ashley Way. I was a domestic family lawyer for over a decade before coming and doing my master's last year at Leiden in public international law. So I'm really appreciative of hearing that there's still a role for international law to play, because I made a huge career choice to come and do that. But more importantly, what I'm seeing now is a huge discrepancy between what I'm learning and what all of these very intelligent, educated, and international law people are learning and hearing today, and what my friends back home on the ground understand. And, you know, that could be my legal colleagues in domestic law, right down to anybody on the ground. And I think that's where UMNA comes in. I'm wondering what role you think journalism has to play in translating all of these complex concepts that can be misconstrued in the ways that we've heard today. Oh, I know we're not supposed to hurt people, but it's inevitable. You know, well, we're defending ourselves. Oh, we're targeting Hamas. Like all of this language that we hear. How could you help us reach the people and make what we do and what we're all working here to talk about make sense to people on the ground, so that we can see domestic efforts more effectively effect change for the better?
And if I may quickly add, Yugna, if you could also share with us what can we do to support the type of work that you so bravely do and many others in conflict zones and in situations of extreme insecurity.
Thank you so much for your question, and it was really nice hearing Professor Vyas and Dr. Fleur speak about and spell out all these international laws and humanitarian laws that they actually, if they were implemented, we would have not reached this stage of devastation that people have been up to in different areas of conflicts. Forgive me for speaking specifically about the Gaza Strip, because this genocide has been going on for 8 months now, where we have started into, or we have got into the 9th month already, with an unprecedented genocide that I can't neglect to just speak about. I know that there are other places like Sudan, what is happening in Sudan, what is happening in Ukraine, what is happening in other areas of the world. But as a survival, or as a survivor of this genocide, and it's still ongoing, I need to be highlighting all these difficulties, especially that as journalists now, why we're speaking out is because other international journalists have not been able to enter the Gaza Strip. They have not been able to report on what's happening on the Gaza Strip. And despite not being able to enter, and despite not, I have said this many times before, failing to obtain and to fight for the right to enter the Gaza Strip and to cover this ongoing genocide, they have also failed, unfortunately, for several months since the beginning of this genocide in actually reporting about it, in using the correct words, the correct terms, the correct definitions of the actions and the scale of actions that was happening in the Gaza Strip. So using very light language to describe a tragedy or a catastrophe that is completely a misconception and unrealistic to what is happening. And I always blame journalists for this, for them being a reason for not spreading out the truth about what has been happening in the Gaza Strip since October 7th. And even before that, the nations of the world, I'm really surprised after I came out of Gaza, going to different countries to speak in different conferences, that people and very educated people, not just some of them were even journalists, have no idea of what is happening in Gaza during all these 6 months or 7 months now, 8 months. Every time weeks and weeks pass, while people are neglecting the scale of the events that are unfolding in the Gaza Strip. And that is the responsibility of a journalist. It's the responsibility of every journalist from every country to speak to their audience, to their people. The support that we find now in the world has come very late. This popular support by the people themselves has come very late, because until our voices as Palestinian journalists have reached the nations, or these nations of the world, so that they can stand up and they shout out and they stand in solidarity with what is happening in Gaza, it took us months and months. And it was a very heavy price that was paid mainly by the civilian population. And that responsibility falls most on a journalist. Because if governments of the world who know what is happening have chosen to neglect those facts, those crimes, those atrocities, and they have chosen to neglect implementing international laws and humanitarian laws, while there are international organizations, many of the UN international organizations are operating in the Gaza Strip, and since the beginning of this genocide, they have been speaking about what is happening in the Gaza Strip. They have pointed out every war crime, every atrocity, and every violation that was committed. But these violations were not outspoken by international media and were not condemned by governments.
I'm afraid we will have to conclude our public lecture for today. As has been heavily discussed today, the situation is extremely dire. International law does offer protections. However, the implementation and enforcement of these protections and the hijacking of legal terminology to perpetuate crimes and to perpetuate violence against Palestinians and Palestinian women in Gaza. I think I would like to again reiterate my thanks to the panel for your great support and for contributing to this lecture. We wish we could have had you here in person, and if not, perhaps on a different occasion. Thank you so much also, Vios, for your very insightful interventions and contributions, and for helping us make sense of the law as well as the situation. Finally, thank you so much to our events team, to Ada and to Floris that have helped organize this, to Walter, our IT and technical support, and also Sarah and Pascal from our communications team that have so spread and disseminated the word about this hopefully important event or useful conversation that we can start and we can continue, maybe with some results in the future. So thank you again so much. We will also be organizing other events on important ICL and IHL topics, international human rights law. Check our website, and you are always welcome to join us in the future. Thank you.